We're live, people. How's everything going? Booyah. All right. Not 5 seconds late. It is Sunday evening. It is time for the weekly live stream with Robert Barnes, which may turn into a bi-weekly or a twice-weekly live stream. Interest pending, which the interest seems to be there because I put out a poll on the community tab, and it seems that there is indeed interest for, if not twice a week, once a week, and then twice every other week. How's everybody doing? Everything's good? If my audio is off or anything, let me know. I saw a funny comment from Fleet Lord Avatar that says, whispering, Viva talks for 5 minutes while Barnes shows up. This is true. And I set the rules out every week so that nobody complains, or if they do complain, I can refer them back to the intro 5 minutes. Okay, this week on the menu for subject matter, we're going to talk about Theranos and Elizabeth Holmes' potential insanity defense. We're going to talk about Julian Assange update in the extradition hearings in the UK. We're going to talk about Cuties because I need Robert's feedback on this in order to formulate a full personal opinion. What else was there? The census ruling in Trump census counting ruling. There was something else that I was supposed to mention. I forget what it is. So that's what's on the menu for the subject matter. For anybody who doesn't know, we then turn this into a podcast, which you can find on whatever podcast platforms exist. It's called Viva and Barnes Law for the People, and we put the entire live stream up in podcast and then sections depending on the week. I want to thank everyone in advance for the super chats. I do my best to get to all of them, but it's not possible anymore, which is sort of like the best problem to have from a growth perspective. So I thank everybody in advance for the super chats. If I don't get to them, I apologize. I bring them up, even if I don't read them, and I do my best to get to all of them, but what a phenomenal thing. We're at 1,700 people 2 minutes into this. It's phenomenal. It's phenomenal, and I know Barnes loves it. I love it. It's a weird thing. The community that is being built around this is amazing when I can recognize a lot of people by names and by avatars. Legal Beagle with Lionel Hutz as the avatar is beautiful. Who else we got here? Let's just say Gooch Naba. I don't believe I've seen this avatar before, but time for Kofefe. And I saw 2 more super chats. I saw 2 super chats before the stream started. We're going to get to them. I took screenshots. And that's it. What do we say here? STFUFFS. I recognize the name and the avatar. Everything, something, the bed. Okay. Sorry, I'm not bringing that up in approval of the comment. I didn't read it before I brought it up. Lots of discussions that happened in the comment section. I do not sanction or approve of all of the comments in the comment section, but it is free discourse. Did I put it on 15-second slow mode or did I not? Whatever. We're living with it. We'll do it live. Now I saw 2 super chats and I can't bring them up to get to them. Oh, here's one and here's 2. Isaac Castillo. I recognize the name and the avatar. Sometimes you need a 5-minute snack of Viva before you get Barnes' meal. Yes. And it's a good ritual. It's a good ritual. You start off with this and then we move into a world of wealth of knowledge. Kate, I would love to watch you and Ben Shapiro have a conversation. I would be game. I mean, I think I would be game pretty much with anybody. And yeah, I don't know how you go about hooking these things up, but any day of the week. I think that guy meant everything shared of Ben. The Real Bambunga, another name and face. I talk with the Real Bambunga on the non-interwebs. You guys are good people. Keep putting out the good. Thank you very much. I see Barnes coming in. He looks good. He looks good this week. See, I get the sneak peek of Barnes before all of you get it. He looks good. Blue suit, magnificent tie, cigar, and I'm never wearing a suit again if I can avoid it. Okay, I think we did the intros. No, that sounds good. Let's bring Robert in because we got 2 super chats that came in advance to answer. I got a couple of emails that I said I would deal with before we got into the topics. Let us bring in the Barnes. Robert?
Hey, how are you?
Good, and yourself?
Good.
You're looking good. All right, before we get into anything, first things first, are you able or are there any developments on some subject matter we have discussed previously that you're able to publicly disclose? In particular, I'm thinking Amy Cooper. I haven't heard any news in a while.
No update there.
Okay. Kyle Rittenhouse, any update there? There was a question that came in. I can't bring it up, but let me just get the screenshot that I took. It was from Corliss SD says, when appropriate, please ask Robert for an update on the campaign to get Rittenhouse a defense team worthy of the struggle ahead of him.
Yeah, I mean, to my knowledge, there's been no change. So the Lynn Wood responded to me on social media because he's been on this sort of campaign against the people that have sued him, and I just pointed out that you couldn't have people were talking about how there wasn't evidence, sworn testimony with references to tapes, transcripts, texts, and recordings. That is what we have as evidence in America. So it's as good evidence as you could possibly have. And the problems just continue to grow in that respect. I mean, the John Pierce, the lead defense counsel, to my knowledge, still for Rittenhouse, turned out he had, several domestic violence orders taken out against him, so forth. It just keeps getting worse for Rittenhouse, in my view, in terms of defending himself in the court of public opinion and potentially the court of law. I had more lawyers reach out to me this week, including lawyers from Wisconsin, that told me it's even worse than I believe it to be or than I've expressed it to be. So unfortunately, it looks like that the same as it was last week. And unfortunately, nothing has changed in that respect.
And it's an interesting thing. We've talked about taking battles to social media and the pros and the cons. We'll get into this during this live stream, the Nicholas Salmon issue with, the ACLU staffer and the professor at Transylvania University. But one of the things that staffer said in his Facebook post about Nick Sandmann was that, he and his lawyer are on social media promoting Q. Now, I don't think that's true of Nick Sandmann. I follow him. I don't think I've ever seen it. I wouldn't, it's without judgment that I say this. I just think it's factually incorrect as relates to Nick Sandmann. But when you have an attorney, his attorney doing it, it allows people to make these connections between solicitor and client, which can be damaging to the client.
Correct. To my knowledge, what that guy was saying, almost none of it was true about Nick Sandmann. He was essentially casting blame on Nick Sandmann for things that Lynn Wood is doing, not that Nick Sandmann has anything to do with. I haven't seen any evidence that Nick Sandmann has any connection to Q, promoting Q, that Sandmann's on any kind of messianic quest or anything like that. That's all Lynn Wood's behavior. And so it's another circumstance where basically where he is defining his clients, his own course of behavior is defining his clients, and not in a favorable way for any of his clients.
Yeah, that's what I think people will now fully appreciate if they hadn't appreciated it before. And I'm not one to give advice to other attorneys in terms of how they publicly litigate files or conduct themselves, but this is the risk. As I was reading that post from what's the guy's name, Crankshaw, and I'm reading, I think some of that seems true for the attorney, but I didn't know of that to be true for Nick. And I follow him, and he follows me on Twitter. I hadn't seen it, and then I Google Nick Sandmann Twitter to see if anything comes up, which doesn't come up right away. And that's the pitfall of that comes with notoriety or fame or infamy. But Robert, what do we start with? Do we want to start with Nick Sandmann just because we're on the subject?
Sure.
Okay, so there's too many things. I have questions about tortious interference. Bottom line, for anybody who has not heard the most recent developments, an ACLU staffer, his name, it doesn't really matter, it's Crankshaw, but he posted to Facebook basically something to the effect, Transylvania University, it's a stain on the university to have admitted someone like Nick Sandmann, who has no openness to learning. He and his attorney are on Twitter promoting conspiracy, whatever you can imagine as being hyperbolic, inaccurate exaggerations, if not outright falsehoods. Posted to Facebook in an edited comment, specifying it's on his own time, his own personal opinion, doesn't reflect on the ACLU, past or previous employers. A professor at the university in response says, this echo chamber of everybody patting each other on the back to show how good and noble they are, says, totally agree with you. If he ever takes my class at Transylvania University, he'll be forced to learn based on evidence, all sorts of self-gratifying nonsense. And what ended up happening? People, a stink arose The university posted a public statement saying, we've become aware of these public statements on social media. As a university, we're not allowed talking about students without their consent, and neither are our staff. Giving a wink, nudge, nudge to the professor, you've screwed up a little bit. Shortly thereafter, the professor comes out and says, I apologize. I didn't mean to target or single out Nicholas Salmon. And the ACLU staffer doesn't apologize because it's on his own personal time and he's entitled to his opinion. First Amendment. I put out a quick video about tortious interference, but are we getting close there, Robert, in law?
It would be tricky to go that route. Essentially you have the First Amendment expansion is pretty broad, so you could have a potential claim against the university if there was actual targeted discrimination, potentially if it's a public university. Private university, not so much. And generally that these kind of legal theories against universities have not really got anywhere. So now to the degree that people are trying to say false statements of fact about them, that can be tortious interference. But a lot of what this guy, and there was some of that because the guy was defining something, claiming that Salmon had said things that Salmon had never said, that he was attributing to Salmon things that only Lin Wood had said. And so I think for tortious interference, you need, with prospective economic opportunity, you need an underlying tort. And that usually is something like defamation. So just interfering with prospective economic opportunity is not illegal. You need some underlying illicit activity, either unfair restraint of trade, false advertising, false statements, defamation, etc. And the same First Amendment restrictions would apply in terms of how much the tort could be used.
And so that was one thing that I thought I had understood. And then it seemed like some principles set out on the American Bar Association were a little bit vaguer, in that they said one of the conditions was an underlying tort, and that it seemed to imply that the tort could be just trying to harm for the sake of harming.
In there's a few states that have that kind of definition of a tort. There's only a few. There's like Missouri and a few others. And generally that tort, that's rejected in most places. It's where courts have come in and they've said, you know what, we don't like what you did, so we're going to just say it's a tort if you intended the harm. That honestly doesn't make much sense. It's not what the tortious interference is originally predicated upon. So I think it's something like 46 out of 50 states you would have to have a recognized underlying tort. There's about 4 states where you could just allege the intent to cause the harm.
All right. And for anybody who's not clear, a tort is a fancy word for basically a legally recognized wrong. So yep. I was, bringing it back to the Oberlin case, but in Oberlin, the underlying wrong was the defamation, which itself is an underlying tort, which Oberlin invoked in order to interfere with Gibson's Bakery's, economic relations with third parties, to say, don't shop there, they're racist, which was the defamation. Okay, so in this case, I guess unless setting aside whether or not it's defamation, if Crankshaw is just doing it to be a jerk because he doesn't like Salmon and he wants to harass this kid wherever he finds him, just to interfere for the sake of it would, in theory, be protected in 46 states under the First Amendment protections.
Well, it's because there would be no underlying tort. So the First Amendment would apply even in all 50 states unless he made a false statement of fact. Because any kind of speech is protected unless it violates a clear tort law. And even in those states where they allow a generic "you intend to cause the harm" tort, his speech would still be considered First Amendment protected, would limit the scope of the tort in this context, if speech is the basis of it, as opposed to some behavior. So the same limitations would apply.
All right. And then the question is, in terms of the professor, like when does this become some form of sanctionable harassment by the university and its staff against the student?
That'll depend on the university's own rules. So universities usually have pretty broad rules that they can punish one student for harassing another student. In the same vein, as long as they're a private university, they have pretty broad flexibility. If it's a public university, they're limited by the First Amendment in their conduct in that respect too.
Okay, so that's good. I mean, that's interesting enough. It's I'm just shocked at like the idea that they have to continue to go after Salmon as though he had ever done something wrong in the first place. Whereas even if he had, at some point you leave him alone. But to the extent that they still think this kid did something bad in the first place, and maybe it's the fact that he spoke at the RNC that has renewed his ability to be despised. It is. depressing and phenomenally absurd.
Well, I think people can see why my clients, because I do not represent Nick Salmon, I represent other Covington kids, all kept their anonymity. So when they go off to college, nobody knows that they're one of my clients. Nobody knows they're one of the cases. So this can't happen to them because their anonymity, we have managed to maintain and protect it despite a massive effort to try to undermine it and expose it by media, including by conservative media, frankly, who tried to out them. We were able to protect their anonymity to this day. And this is why, because the Salmon's going to face this the rest of his life.
It's depressing and a little irritating. Abdi Muhammad says, I just watched a program on Swedish state-owned media about Alex Jones, and interestingly enough, Robert Barnes was on it. What are the chances? I would say 100% based on the based on the chat. That's very cool. And Little Rock incidentally put out a nice super chat. I missed the live stream last week. Wife and I took kayaks fishing. I am here tonight live at the office working on a brief and trial tomorrow. Mm-hmm. I love watching you guys. Wouldn't it be nice if we could get CLE for this? CLE is continued learning education. And I was actually thinking of, I still might do it, contacting my local bar to see if we could actually, make something like that happen. And I did notice one other super chat come in here. Oh, did I not do the super? Oh, Julie T, no super chat here. No comment, but thank you very much, Julie. Okay, good. That's cool for Sam. And I want people to appreciate what's going on with him and what he still faces going forward.
And one point of clarification while you look up those other two super chats. Because various people were asking why I was saying anything at all on social media about the whole Lynn Wood situation. The only reason, or John Pierce, the only reason is because of Rittenhouse needing the best defense and a lot of lawyers reaching out to me saying that they have grave concerns for the nature of his defense. And so the only request that's being made is simply for Lynn Wood and John Pierce to return the money that they raised for Rittenhouse to Rittenhouse. That's it. Nobody's asking for anything more than that. And then let the family make an informed decision about their defense and how to use those funds, including using them for bail, which will be critical, and using them for their safety and security pending trial if bail is granted, as well as legal fees, rather than using the leverage of controlling the money for their defense as a tool to decide for them who their lawyers are going to be. Some people have reached out and said, well, why haven't you, Mr. Barnes, reached out directly to the family? What Lynn Wood did is, and John Pierce did, is unethical. You are not supposed to directly target a potential client and directly solicit them. So I'm under going back to tortious interference. If I directly targeted and went up to the client, either the Rittenhouse or his mother, then then I could be attacked for tortiously interfering with their existing legal client relationship and for engaging in direct solicitation and contravention of the rules. So just because Wood and Pierce did it, apparently, doesn't make that legal or ethical for other lawyers to do. So that's the reason why people are publicly speaking out. They are not in a position where they can resolve this privately. Many tried. I tried. They refused to answer the questions, and it cannot be resolved by going direct by as lawyers. We cannot go to Rittenhouse. Non-lawyers can talk to the family, but lawyers can't talk directly to the family. I mean, I have problems with that rule, but that ship has sailed. That rule has been upheld. So so that's why. And so I have no ill will towards either lawyer. I just believe that, and a whole lot of other highly skilled, capable lawyers believe that Rittenhouse's defense is in great danger and great jeopardy as long as he's represented by two lawyers who have massive problems on their hands. And Lynn Wood is not taking any responsibility. He's attacking the three lawyers who sued him. In my view, he's defaming them, like he libeled me again on the media. I never said I represented Sandman in any capacity. He just keeps that lie on his messianic pitch. The guy, I believe he's completely lost his mind. Other people have come to the same conclusion reading the complaint. And the complaint is a verified complaint where all three lawyers signed it under penalty of perjury. Anybody who thinks three young lawyers risk their future, risk their careers by lying under oath and falsifying all the evidence solely to get back at Lynn Wood are not living in reality. And the people that are pretending that Lynn Wood is the right lawyer for this situation or Pierce are the people who are putting Rittenhouse at risk. And it's only because of Rittenhouse I'm talking at all, because obviously I was going to take heat for this and already have. So this is about Rittenhouse, solely about Rittenhouse. They have an easy remedy available to them. Hopefully they take it. If not, Rittenhouse, unfortunately, is the one who's likely to suffer for the consequence of their malfeasance.
Okay, I mean, it's a lot of people have been asking, and I mean, a lot of people are concerned, and a lot of people also want to know how to help. So I guess sharing and reaching, sharing and tweeting and raising awareness on social media.
Yes.
If you take your chances doing it, because I understand now Facebook and YouTube might be actually punishing people for showing support for the Rittenhouse defense. But I mean, I haven't.
And one little side bit on that, there was some question raised about that being a sort of effectively, it's a one-sided gag order that's taking place. So what happens when social media doesn't allow the people in the court of public opinion, or even the lawyers, to publicly defend their client in the court of public opinion? Now, Wood put out something saying that violates the First Amendment. It does not, because all of these are private actors. Now, I disagree with that. I believe once you reach social media monopoly status, that you should be considered a government actor if what you're regulating is the public square. However, that's not what the courts have said. So the courts have made clear that they consider all of these private entities. So none of the First Amendment does not apply. Or the rest of it. That's where there's frivolous. There was John Pierce was apparently recommending, in response to people's social media comments, creating a publicly funded lawsuit against social media, where people would, that's just a bad idea. It's a bad idea for him to be involved in public fundraising at all when he has all these financial problems, allegations of fraud, massive debts in the millions, sued by everybody and their brother, effectively. So that's my concern. I don't have concern for these lawyers personally. I don't go around trying to police the legal practice. It's when it impacts public policy, when it impacts potential individuals like Rittenhouse. But right now, there's nothing that can be done about that. And it's going to be a problem in the future. If what happens when private social media imposes the gag order instead of the court does it, I can appeal it, get it reversed, overturned. It violates the First Amendment. What happens if Facebook does it instead?
No, it's and I mean, it's not necessarily one of the topics, but Facebook announcing that it's going to block certain posts about the fires out west on the basis that it's false information. It's not just scary. It's because we've been warmed up with Orwellian books and tales of cautionary tales. It's just Orwellian. I mean, they're making the determination, Facebook, that something is factually incorrect to the point where they make the decision to remove it from the platform, among the biggest platforms for communicating information among individuals. It's madness.
Completely. And right now, the only approach is a public shame campaign against the social media giants.
Yeah, well, there's no alternatives to Facebook, Google, YouTube, and Twitter. So public shaming is going to do no good when you have to shame them on the very platforms that you're trying to shame.
Exactly.
Okay, let's see. We got Michelle says Rittenhouse family was doxxed by those wishing harm. So while their social contacts are largely shut off, there is still a way to communicate. Call it irony. We got Lawrence Van Dorn says that's why I contacted Aaron Decker, a GOP supervisor for Kenosha, and begged her to reach out to Kyle's mother and have her reach out to you. I hope she passes the message on. There was one more here. Let's do this one. This one says, I'm so grateful for the two of you. Honest and brave analysis is rare now, unfortunately. We're going to wait until we get into the brave one, because the first topic that we're going to be dealing with is going to be an interesting one. Repealed CDA Section 230. Well, Robert has had his suggestion as to how to remedy this abuse.
Yeah. It's just to condition it rather than repeal it. Use it as a carrot and a stick. Use Section 230 as a carrot by saying that as long as they comply with the First Amendment, if you are engaged in a social media application that regulates the equivalent of the public square, and there's ways to have that definition legislatively done in a simple manner, then you only get to be immune for what anybody does on that public platform as long as you comply with First Amendment standards, which already exist and are well defined. Governments do it every day all across the country. And my view is to use that, so that way you're not creating a super imposition on the private sector that could create a dangerous, perilous path of its own kind, while at the same time you're protecting actual free speech and free thought and free expression. And you're doing so in a way that does not protect child pornography, because that's not protected by the First Amendment. Doesn't protect stalking, doesn't protect harassment. All of that is outside of the protection of the First Amendment. So it was what I pitched to Senator Hawley several years ago. Senator Hawley's coming back to that position. Recent legislation proposed in that way, but frankly, it will depend on the outcome of this election, whether or not that legislation has a chance.
People are saying that the stream is skipping like crazy, and I brought up some other chats earlier. Well, can't do anything about it, so we'll see if it's smoother on the rerun. Okay, let's do. Speaking of not protected First Amendment rights, Cuties. I'm not even going to ask if you've watched it, because my first question is going to be, if it is deemed to be child pornography, is not everybody who tweets and retweets it committing a breach? But before we get there, for anybody who doesn't know, Cuties is a Netflix movie. It's a movie that's being aired on Netflix. It's a French movie. The movie's called Mignonne in French. It's the story of 11-year-old girls coming of age in a world of hypersexualized prepubescent girls on social media. The main character comes from a Muslim family with traditional, I would say they're only Muslim values, traditional values that do not look kindly on hypersexualizing young girls on social media. There are some scenes there's some content in that movie that is itself questionable, to put it mildly. Everyone's been tweeting about it for the last 2 days, to the point where people are saying, if you're tweeting the offensive, shocking parts, you're sort of contributing to the problem. Tulsi Gabbard came out and said this is CP. We'll just call it that throughout the rest of the stream. It's terrible. It's potentially criminal. Tom Cotton comes out, says the same thing. Ted Cruz writes a letter to Attorney General Barr, asking him to look into it. Did they break federal laws? I guess I didn't miss any details. Starting from there, Robert, I mean, I didn't get into this in my video that I put out today. Canadian CP laws are even stricter than the U.S., but they're pretty much on, they're quite strict in the U.S. nonetheless. From what you've seen, is there a plausible argument that this actually violates federal law?
Probably not. And I think it's because people are confusing the word simulated in the statute. So for pornography in general, there's a constitutional limitation if it's adult people that are being featured. Because in that context, it's whether or not it's obscene under the First Amendment. I saw people trying to do an artistic analysis. That doesn't apply if it's children. Any pornography involving children is illegal in the United States, period, and not protected at all by the First Amendment. Only pornography involving adults can be if it meets certain artistic standards such that the court no longer calls it obscene. Unfortunately, that's where our legal standard famously comes from, the statement of the Supreme Court Justice who said, obscenity is, I know it when I see it. That's what it is. It's not the greatest legal standard ever articulated. So that's the first part, is that if it is pornography involving children, it is unconstitutional, period. It's not constitutionally protected. So the question becomes, what does the statute define? Now, there's probably some constitutional constraints on what the statute can define, and those, it has to actually be pornography. That has always required graphic behavior, the depiction of graphic behavior that usually requires either nudity or the sex act itself, or the simulated sex act, not someone doing a dance routine. So the first time this came up was Britney Spears. Is the last time I remember this debate coming up legally. People should go back and, well, I don't recommend watching it, but when she was 15, she was doing things that are there. I didn't watch this either, so I'm not commenting from a place of knowledge. I can't watch things like this. Same with, I remember years ago, someone recommended I go into becoming an FBI profiler, someone that had connections to that world for serial killers. And I was like, I can't stay inside a serial killer's head for days. That will drive me insane. Might be good at it, but don't want to do it. Same with child pornography. I just can't deal with it. I always referred those cases out where someone has an issue there. So I'm not going to watch the film. I've heard the defense of the film. The defense of the film is that it's trying to be critical of this by depicting it. I've always had a problem with that. I don't think it's well. I think there's ways you could talk about how it's being portrayed without actually portraying it. I think it's a problem to actually portray it. But what they're portraying by our legal definition does not meet the definition of a crime in the United States, because what needs to be simulated is an actual act between two people and things of that nature, or nudity that can be seen in a lascivious manner. These dance routines from the Britney Spears days are not considered a violation of the law, and there probably would be some constitutional questions at that point because it does not meet the historic definition of pornography that's outside the protection of the First Amendment.
But so, and I mean, I was looking through the federal statutes that Ted Cruz listed in his letter, not knowing anything more. Under the definition of sexually explicit conduct, it said real or imitate, basically real or simulated. One of them was masturbation. So, I mean, I have not watched the movie either. I'm not going to watch it. I have no interest in watching it. I know the plot and I know the message, and it's great. I don't think you need to use 11-year-old girls to make that message. Sort of like abusing an animal to show why animal abuse is bad. It's right. It's illogical. But the statute under sexually explicit refers to masturbation. Part of the dance, arguably, if not arguably, shows hands on crotch. And part of the statute also says sexually explicit is focusing on the groin or anal region, which I think, that dance scene in particular, arguably or not arguably, focused on. And so the question
they would need nudity. And it was for that form of simulation to be pornography under the law, they need nudity to be attached. So they simply wanted to make sure under the statute that when you're depicting a sexual act, that if the sexual act itself did not occur, you could still consider it pornography. But in that context, you need nudity for it to occur. So there are circumstances where you can have a simulated act and not have nudity, but it needs to be a truly simulated act. For that one, you would need nudity for it to be considered a crime of pornography under the statute.
All right, now in case anybody else's head out there is exploding, there people are going to say what they were doing, when they were gyrating on the floor was a simulated act, maybe more graphic and more explicit than, hands on the groin.
But without nudity, it wouldn't be a crime under the law.
Okay, that's interesting. I mean, it was not knowing anymore. Because I think in Canada we're getting very close to what might be recognized because we've had even more peculiar cases that had been recognized, overturned on some cases. There was an artist who had hand drawings, or they were sketches that were recognized as child pornography, overturned on appeal. There was another situation where an individual had images which were indisputably CP, but also had short stories that the person was writing to themselves. And that portion of it was deemed to be an exception because it was private writings for his own personal consumption. So we've had extreme cases of severe application of the law and carve-outs that didn't apply in this case. But a lot of people, myself included, are thinking what they were doing with their hands, what they were doing on the floor for 11-year-old girls, sounds like it qualifies as child pornography under the statute as defined, but I mean, if not, then not. Another question. I mean, what about are there child exploitation laws that might apply to this particular movie?
Probably not. I mean, to my knowledge, they filmed it in France, so I mean, unless so there wouldn't be U.S. laws that would necessarily apply. There's certain sexual trafficking laws that apply internationally, but not labor exploitation laws. Generally require a U.S. jurisdictional nexus to the actual performance of the labor, not just the display of the film. Now, child pornography can be made anywhere, and it be considered illegal. And the way I look at it is, could they expand the statute to include this? And I think Jonathan Turley is probably right that would probably raise some constitutional questions. That historically it's always been the explicitness of the behavior that has been banned, and it was always debated whether simulated behavior should be banned. Also, early constitutional challenges to child pornography laws included fake images. So the fake images are common in the child pornography world. And they said, no, that can in fact be banned. So you don't have to have an actual display of actual sexual behavior in order to it be considered child pornography. But they've limited the scope to where simulation can go such that it doesn't reach things like what I always called it the Britney Spears of the world. So that was considered excluded from the definition of child pornography, such that even if it's suggestive, it's not a simulated sexual act. Basically, simulated sexual act is meant to be that you believe they're actually engaged in the sexual act in a graphic way. That's the idea. So that there's some form of genitalia or something like that being actually displayed, or you think it is. And they use simulated to just get at situations where they're pretending the act is taking place, but they're convincing you it's actually taking place when in fact it's not. If you understand that, what people are thinking of when they think of simulated is they think of suggestive. And as they're looking at something and saying this person is imitating a sexual act, they're trying to be suggestive of a sexual act. That has never been a crime, and it'd probably be issues with making it a crime. Is my best guess. I understand why the public outrage is present, of course, and in the context of California passing crazy laws that are expanding, are intended to basically functionally lower the age of consent, raises people's moral outrage is absolutely justified. But right now, given the way the laws are written and given the constitutional concerns with how that language is used, it's unlikely that what's portrayed in the film would ever be against the law in the United States. I think it may violate the law of other countries that have stricter regimes and don't have the same constitutional constraints on films like this.
Yeah, I mean, and one example, just in terms of simulating masturbation, someone doing the gesture with their hand is simulated masturbation, whether or not it's explicit enough. So, I mean, these were some of the thoughts that I had in terms of if they are in fact going to qualify this as, potentially or bona fide child pornography in the States. There's a whole bunch of other problems in terms of what's on TikTok, who's sharing videos like that on TikTok.
Anybody who possessed the film could be prosecuted. I mean, that's the other reason why that it won't ever happen. They will never define this film as child pornography here. And my guess is it was legally cleared by people before it ever went up on Netflix in the United States.
Someone had raised the point, though. There apparently, again, I haven't watched it and I don't know, but apparently there was not a topless scene, but rather an exposed breast of a child in the movie.
Oh, I did read about that. They say that's in what is there's a description about nudity being in the movie, but it's not of a child.
Okay.
Because that would be problematic
if they were to show, but then it gets into the question of you have the diaper ad where you have exposed kids, but
that's okay because it's not lascivious. That's the other component. So nudity combined with lascivious sexual suggestiveness constitutes child pornography.
And you know what I mean? While we're on the subject, I mean that I think clears up a bulk of the issues. Actually, first question before we do that, hypothetically. If it were, for whatever the reason, recognized to break the law, would it not be the case that everybody tweeting and retweeting, even if it's for critical purposes, would be themselves violating the law?
It depends on whether what they have is considered possession or distribution. But yes, but that's where people were not putting two and two together. It's like if this is child pornography, you cannot have it, you cannot reference it, you cannot possess it, you cannot distribute it. If it was child pornography, anyone who possessed it, which means anybody who downloaded it, anyone who shared it, would be subject to liability.
And no joke, when I retweeted Tom Cotton's tweet, his tweet referenced something that had one of the images, which, being a little neurotic, I started, I didn't fully appreciate when you're tweeting it, you're tweeting everything in whatever. So I got a little nervous and I said, well, if it is indeed a problem, everybody who's retweeting it now is sort of potentially breaking the law as well.
Right. Which is another reason why they're never going to call it that.
Okay. Now that being said, now on the subject of young people and what's going on in California, can you explain to the world what's going on in California in terms of the law now that wants to effectively? Yeah, go ahead. I don't even think I know it. I understand it, but I'm not sure I can even explain it. What is the modification of the proposed law that they're putting up?
Functionally, they're changing the age of consent for certain sexual behavior and sexual acts. Theoretically, they're doing it their political justification for doing it is to deal with the high school problem. One high school person's at 18 or 19, the other one's 17, they're dating, and not make that a crime. There are ways to do that without doing what they're doing, which is that there can be a 10-year age gap up to a certain range, and it's no longer illegal to commit certain sexual acts as long as you're within that 10-year age range. So 15-year-olds with 25-year-olds, that kind of thing. And I call it functionally changing the age of consent. They're trying to erode the age of consent restrictions such that fundamentally they're going to start here and then they're going to keep going. There's been a side of the left which embraces that treats pedophilia as just sort of a different mental approach. I mean, it's what happens when you start saying gender's not biological and everything else. You just start it's hard to stop going down a path that doesn't take you to someplace like that, which I think most people find morally horrendous. But that's functionally what they did in California. They changed the age of consent for certain sexual acts depending on the age of the two participants in ways that was illegal yesterday.
Okay, that's amazing. Okay, very interesting. Now, on the issue of consent and age and it being lowered, San Francisco, I just read, this was not something that we had announced we were going to discuss, but I saw it today and I want to ask a question about it. San Francisco is proposing lowering the voting age to 16 for local elections. What I mean, for someone who doesn't understand this, what are the laws on local elections? What are the laws on federal elections? And can this be applied to federal elections to effectively lower the age to vote for the president to 16 from 18?
No, for federally, that's governed by the Constitution, which is why they had to pass an amendment to take it from 21 to 18 years of age. So they would have to pass a constitutional amendment to go below 18 for election into federal office, which would cover, of course, congressmen, senate, and electors for the presidency. But what they could do is change the local office and arguably state office, depending on the circumstances. So they clearly are trying to expand the dependent groups. I mean, I think San Francisco also allows illegals to vote, if I recall correctly. You don't have to be a citizen of the United States to vote in the San Francisco election either. And right now there's no constitutional constraints effectively on them doing that.
Okay, that's also interesting. Okay, hold on. I want to bring up this super chat because I know it's an interesting question. What is Barnes' thoughts on the family court system and how it leans towards the woman, even if that's not in the best interest of the child? Can that be changed?
So what he's referring to is a lot of judges say, well, in my experience, the baby ducks always follow the mama duck, so I'm going to give custody to the mom. Which it's one of the few places where women have an advantage. There's a lot of places where women are disadvantaged by our legal system because they're disproportionately our legal system. Our judges are overwhelmingly men. But of course, a lot of them discover that having more women judges doesn't change that equation. In fact, a lot of my experience, some women judges are more biased in that regard than male judges often against women, interestingly enough. For example, women. So there's certain patronizing perspectives that men have that can, in certain legal contexts, benefit women culturally and historically in the United States, at least. And one of them is they win custody battles at an extraordinarily high rate. That's beyond what could be explained by simply the facts of those cases. So that is an issue, and it needs to be corrected. And people need to look at what is in the best interest of the child, but particularly do so without having the influence of so many social workers and increasingly, basically, a child psychologist makes the determination. And we're seeing what that looks like. They're saying, well, I'm going to take a 7-year-old and change their gender, which I find deeply problematic. So that's the path. So we have serious problems in our family courts is the short answer, and it's getting worse rather than better because they're letting child psychologists and others seize influence, and their cultural political biases are often dictating their decisions, not good science or what is in the best interest of the child, in my belief.
And incidentally, I had done a vlog on this in Canada because talking about what happens when politics ruins everything. When the medical community becomes politicized and you have psychiatrists coming in or psychologists coming in with their political baggage, identifying what they think is in the best interest of a 14-year-old who wants to transition and take hormone therapy. And we had a case in Canada where a kid wanted to take, hormone therapy to transition. The father was vehemently against it. But, the medical professional said it's in the child's best interest. And the court agreed. I haven't followed up on that in a while. And then there were some whole issues about them gagging the father and not letting him speak publicly about the case, not identify the kid who was subject to ridicule. It's.
I'm not in favor of the state getting involved in these matters as much as possible because it almost always will go against the community's interest and the public interest.
Okay. Now let's see. This might be a good segue. I want to, you know what? No, hold on. Let me just get a couple of super chats before we do this because I didn't bring them up. Let's see here. We got Joshua Worley says Sylvain de Zangrois, not Maimouna Douceret, is the mind that's really behind Cutes. Look him up. His IMDb and Wikipedia page have been scrubbed. He auditioned 650 girls for the role. Just getting back to Cuties, actually. That was one of the things that Ted Cruz also said that struck me is if this is not as bad as it was, and this made it the cut, you know, what other stuff might have gone on when shooting those scenes that might need to be investigated. But do you think, do any chance it gets investigated, or it's out of their jurisdiction? They're not going to France to do anything?
It's that unless they have specific more evidence, that then no, they're not going to get involved. I mean, one, because it's a French issue, so they can make a referral to the French. But in that aspect, because all that matters here is what got distributed. What happened behind the scenes that was never distributed, that's an issue for the government of France, not for the United States.
Okay. And this one might bring us into our next subject. Presidential election. If a poll worker in an individual state wants to commit fraud with the mail-in vote, can Trump sign an executive order beforehand like he did with the statutes to make it a 10-year crime for the offense? Dapper Dave, thank you. Good question.
Two components there. The law was already on the books, making it a 10-year crime. What Trump did is he just made clear that how it would apply. So he didn't. Trump does not have the power to make anything a crime. He can simply clarify that certain laws are already on the books because it's up to the legislative branch to define what a crime is, and then Trump signs that into law. But his executive orders just clarified that laws that were on the books would be enforced. So what he does is he determines what's prioritized in terms of enforcement, rather than actually write the law itself. So it's only what laws are on the books currently, and there are federal laws on the books that preclude various forms of election fraud. He could highlight those for federal enforcement, but that's about it.
Okay, good time to talk about. I guess we'll do the census decision that came out and the impact it's going to have. I think I understand this. I'm not sure that I do, but Trump was trying to get Trump, I say broadly, was trying to get additional information on illegal. Well, let's just say not undocumented. I don't know what the term is anymore without getting into trouble.
Non-citizens.
Okay, so non-citizens. Trump wanted to get information on non-citizens in certain districts to remove them from the census.
Or, well, the other way to think of it is this way. Historically, the census had, up until, I think, 1960 or so, it included, in terms of the data it gathered, whether someone was a citizen or not. And then they quit doing that, and Trump simply wanted to reinstate that. And part of the reason for that was the state of Alabama has brought suit, claiming that what's going to happen, and that what has been happening in past censuses, is that the apportionment clause of the Constitution is being violated, because what happens is the census, how many people you have, determines how many House seats you get and how many electors for the presidency you get. And also, by the way, it also dictates a whole bunch of federal funding packages, tends to be apportioned equal to the population. Now, there's actually a constitutional restraint on taxation that's apportionment, but for these purposes, that's not pertinent for the most part. So the state of Alabama's view is what's happening is apportionment requires citizens, and what's happening is non-citizens are inflating the number of quote-unquote people for apportionment purposes in states like California, New York, and Illinois, especially, somewhat Texas, and is giving them more House seats and giving them more electors for the presidential election, and then also distributing certain financial resources that are distributed according to population under the apportionment clause that violate their equal right to representation under the Constitution, the state of Alabama. So Trump also, because of that suit, was trying to satisfy that suit by excluding from the apportionment provisions anyone who's a non-citizen. So the only way to do that, now you can't have legal status within the United States and be a non-citizen. So, but basically, citizenship status and legality, your status of your legal presence in the United States, shapes whether or not you should be included for the apportionment clause. There's some people that have a contrarian argument, but I don't think it's the better argument historically or constitutionally. And so, but the only way you can do that is by counting them. In other words, if you count just everybody who lives in a district, regardless of whether or not they even physically reside in that district, they just happen to be there, say, and whether or not they have legal status to be there, then what happens is the people who happen to have an inflated number of people inside that state on a given day get more power. They get more seats in the House. They get more electors for the Electoral College, and they get a greater financial resources distributed to their state under the federal programs that are apportioned. And that's the constitutional problem. So, but the only way you can resolve it is by making sure you distinguish which of the people we are counting are actually both physically and legally resident within this state, not just are they physically resident within the state. And if you don't count it, then what's going to happen is you're going to have an overcounting. And what the court did is the court is disallowing him from counting it. So it's the court's judicial activism once again, because this has never been thought of as unconstitutional in all the prior censuses we did it. It's just now because New York has more power, if more seats, more electors, more money from the federal treasury, if they include illegals. Same with California, same with Illinois.
I didn't read the judgment. I couldn't get a feel for what the rationale was from any articles. What's the justification? What's the legal justification for that?
The only that it wasn't done in the last census. That's the only legal. The other legal justification is that somehow it's discriminatory to ask for the legal status in a census, which doesn't make sense to me.
If I'm thinking outside the box, I can think of maybe not just unfair or illegal to ask, but it might expose them to deportation potentially if they have to identify themselves.
Correct. The theory is that you will not, quote, get an accurate census because people will not answer or participate in the census if they're not legally present here. My problem with that is that's not the point of the census. The point of the census was to get our legal population here, not to include the illegals ever in it. That's why, certain diplomats were not included historically. There's a certain people from foreign armies would not be included. So the goal was to not count every human being within a state. It was to who just happened to be there. Also, people that happen to be physically residing there, but were not legal residents. They're on vacation, they're traveling, whatever. So historically, it's always been who are the legal residents within the state, because that's the purpose of apportionment. That's the effect of apportionment. And that's the point of the census. The argument from the left is, no, the point of the census is to count every human being who physically resides there. And that's what the court adopted. But that's not, in fact, historically what the census was supposed to do. And it has the severe constitutional problem that some states are going to have more representation and more money than others without it conforming to the constitutional restriction of being related to legal residents within that state.
I'm going to bring up this chat because it's on the subject. Can you please talk about the fact that the census imputes part of the population? They don't answer, so we are going to count them anyways.
They try for the census itself. Like the Census Bureau will do a lot of imputing between census years. So the census is done in 2020, the next one will be done in 2030. In between, they do like the American Community Survey. They do a bunch of other surveys as sort of both to gather information, develop things. And in that context, they impute a lot. They don't try to interview every single person. They try to impute. Their ability to impute for the actual census is limited. So they can under certain limited circumstances, but most of the imputing that takes place between censuses, not for the census itself. People see the Census Bureau produce a lot of data that says we impute X, but that's for non-census reports. In other words, those are American Community Survey 2018. We're going to just talk to 100,000 people, and we're going to impute from that what the educational attainment status is of people of Hispanic ancestry. That might be 30 million people, say. So that, but she's right that there's a problem with any imputation occurring in the actual census itself, because that's where you're supposed to literally count every person. And if for some reason you couldn't reach them, you're not supposed to impute their presence in the census because of the apportionment problems it creates.
So this has no impact. This has no impact on the presidential election or the outcome of the presidential election. It's not to quell
Not this one.
Not this one. Okay. Now you say not this one, but then which one would?
The 2020, because the 2020 census will change how the electors are apportioned amongst the states. So if you count illegals, New York, Illinois, and California will get more electoral votes because they'll get more House seats than, say, Alabama and Mississippi. because the illegals are counted for the purposes of apportionment if that's what happens.
All right. Interesting. And now AM says maybe Barnes bows best, but I was sure a SCOTUS decision allowed the census to impute the count.
She's correct. It's not the historical application, because once you start imputing, where do you stop? You're supposed to count every person. Censuses go back thousands of years. I mean, that's the beginning of the New Testament is describing a census going on by the Romans at the time. And you're supposed to go door to door and count everybody. And if you didn't find them, you don't count them. She's right that they have allowed certain amounts of imputing the population where you're unable to successfully count them all. But I don't think it's still limited. They're not supposed to do a lot of it. They're still supposed to try to reach as many people as possible. And in my view, that someone shouldn't be counted if they couldn't reach them.
And does this go to the Supreme Court, or does this have any
high likelihood the U.S. Supreme Court gets involved because of the constitutional consequence, and because there's other litigation pending in other jurisdictions where this issue is being litigated.
Okay, that's very interesting. Sorry, and this was in New York State?
I believe, yes. I believe it was New York State, Second Circuit.
And now the judges, I think I looked them up, but am I wrong in thinking that they might have been 2 GWB appointed judges?
No, I didn't look them up, so I would trust your judgment on that. That would surprise me.
Trying to remember the names. It's sort of become a reflex of mine. I don't make it an issue unless it becomes a central issue in the discussion, like with Michael Flynn. I just curiosity now has got me looking it up as a rule. Okay, that's interesting. Should we discuss another topic?
No, I think that covers the census.
Okay, excellent. Now, what do we want to do? I think we want to talk about Theranos for a second. I'm going to just get the time on this one. So the Theranos fraud, Elizabeth Holmes, for anybody who... Is that
how you pronounce it? I always think of it as Theranos, but maybe you're right.
Oh, I'm saying Thanos, I think, is the guy from Infinity Wars. I don't know. So Theranos, it is definitely.
Yes.
So if for anybody who doesn't know, Elizabeth Holmes, the first woman to become a billionaire under 30, I think, determined to be a massive fraud. We can let him come down. Yeah, so he can come down. Okay. Got a kid who's not feeling well.
He heard about Theranos and just started crying right away. He understands the trauma of what occurred.
So for anybody who doesn't know, Elizabeth Holmes, youngest billionaire woman ever made, turns out to be a total fraud. Theranos, which was supposed to be able to detect, I want to say, what's the word? Diabetes, or was it basically supposed to be able to do blood tests overnight?
Within a minute, you'd find out whether you're at risk for a certain disease and get early treatment, or early diagnosis, so that you would get early treatment. And this would basically be revolutionary. And it was applying sort of the mindset and mentality of Silicon Valley to medicine. And the people who vouched for her, the Clintons vouched for her, Joe Biden vouched for her, General Mattis vouched for her. This also involves a lawyer that was connected to it, was David Bowie's. Who helped, in my view, cover it up for a while. Somehow he managed to dodge criminal investigation indictment. But it turns out all along that it could not do what she said it could do. And so she just engaged in massive fraud to raise a lot of money based on a fake story. And it shows the gullibility of people in power, that they promoted it and propagated it. But it also shows how our justice system works. None of them are facing any consequence, only she.
Okay, it's very interesting. Now, and the falsification, from what, if anybody's not familiar with it, involved like outright falsifying medical reports, like top to bottom fraud. She is now discussing potentially, I don't know how serious the discussion is, but it was in the news, raising an insanity defense. Have you ever seen an insanity defense raised on a prolonged scheme like this?
It would be really tough. So traditionally, and it gets into insanity is so legal or so limited in the United States that it's difficult to really successfully wage it. And as I think it may be true, there's people who think that about her. I think she had a family member who died, and so she convinced herself these things were true when they were not true. The nature of most successful frauds is that the fraudster lies to themselves as much as in order to be able to successfully lie to everyone else. And so the That is like those guys that do that behavior panel that look at body language. There's 4 guys that do it on YouTube that really do quite a good job. What they're mostly capturing is that people who lie to themselves behave in a certain way in terms of their body language that will often give it away, and they will call that signs of deception. But it's often by people who have lied to themselves before they're lying to others. There is just their unconscious mind may be cognizant of it, or other giveaways that take place. The inability to retell the story backwards, for example, it tends to be a tell that someone has difficulty lying successfully. So yeah, I mean, the insanity defense of the United States is really limited. So it's not just that, hey, I did something because I'm crazy. It's that I did not have the mental faculty to form an intent. That's what insanity is in the United States. It's not just crazy; it's craziness that removes your ability to know what you're doing.
I mean, and that's what I think. I mean, I don't know if she's going to be, I want to make a joke, insane enough to raise this as a defense, because that's the issue. Is it's not a question of mental illness necessarily. It's a question of mental illness compromising one's ability to form the mens rea. But I referenced John Ronson's psychopath test book, where if anybody needs the cautionary tale as to why you don't do this, one of the it's a real character. I don't think they ever name him in the book, but an individual who was convicted of gross bodily harm or accused of gross bodily harm decides to plead insanity, and gets believed and gets put into Broadmoor, which I've never known existed until this book. And basically, once you're in the mental institution deemed to be insane, you never get out until the doctors deem you to be not insane or what's the word, rehabilitated. And so this guy ended up in a mental institution for the criminally insane, unable to get out because the harder he tried to convince them that he was just, he lied when he pretended to be insane, the more insane they thought he was. Ended up spending more time in there than his sentence would have been. And it's not the only time that something like this has happened, when someone gets into a mental institution and then can't get out.
She's basically banking on a pity pitch as most lawyers know, if the judge allows the insanity defense, it's mostly a subtextual way for a jury to let guilty people go free. And they usually do so because they feel sympathetic to the individual for some reason. And then they know that it's up to the judge what the sentence can be. The judge could release them the same day if the judge determines they're now sane. So that's really what I assume that's what her hope is. Her hope is to game it in that direction. And it may be the case that she thinks there's no chance she gets acquitted otherwise, that they will find that she was out to lie and that she did in fact lie, and that she doesn't have any outs based on the evidence that the government has accumulated in the case. In my view, she always had an out if she named other people as being knowledgeable about it, complicit and culpable with her, because there were some very big names of people that could go down. Now, of course, our government tends not to go after those kind of people, unless they're in the Trump world. So but that, in fact, if that's the case, if I was her defense lawyer, that's what I would keep threatening. Because if the government doesn't want those people named and implicated, then it could lead to a favorable plea disposition, just so that she doesn't implicate them as part of the deal. People would be surprised how often that kind of thing happens in our cases.
People are learning the dirty tricks of the trade from these streams.
Exactly.
I want to, interesting thing, getting back to the John Ronson book, just so that people appreciate that the individual in the book did not, he when they found out he wasn't insane, they determined that he was actually a psychopath, because it's one of the traits apparently from the psychopath test is remorseless manipulation of those around you. And I have a feeling, I don't know how publicly this defense had been floated, but I have a feeling that anybody reading this is going to have an unsympathetic view towards her ability to accept responsibility for what she's done. They might think she's a technical psychopath, but they won't think she's criminally insane. So it's
correct.
A silly thing to. I think it's an absurd proposal, even if it's serious, and I think it's more dangerous than it is of a defense. But
it's a pure Hail Mary. Now, if you're in a situation where that's your only option, it's 98% chance guilt, then why not throw the Hail Mary?
I think I'd probably, because having read that story, I'd rather do less time in jail than get locked up. We used to do motions for confinement in the early stages of my legal career, and we would go to court, represent the hospitals, arguing why a patient needed to be continued to be placed under supervision for their own safety or for the safety of others. I vowed never to do it again, because the amount of times you see these protective orders being issued on people who don't need to be locked up in a mental institution it would blow your mind.
Oh yes. Our mental health institutions are a disgrace in the Western world.
Yeah, it's that would be a discussion for another day when something is relevant in the news. But it was depressing, it was shocking, and eye-opening. But
yeah, I mean, basically, if she's coming up with this on her own and foisting it on her lawyers, then I would give her a copy of both the book and the movie One Flew Over the Cuckoo's Nest. So I wonder who had an hour and 4 minutes on the over-under of my referencing a book or movie. But whoever had the over might have prevailed.
You know what? We're going to get to that. That's the next question I'm going to do. I'm not going to be able to bring up the chat, but someone had asked, is it normal for more than one person from the census to show up on the same address twice?
That's normal, yes. In other words, because what can happen is they're making sure they got everybody inside a building in our house.
Okay, and then
so it doesn't happen very often, but like the census has certain parts of the country that they always have difficulty with. I always find it kind of humorous. It's like the census people come back and say, "Man, went up to the reservation, can't get anybody on the tribe to participate." It's like, I wonder why Native Americans have a little bit of adverse reaction to people from the government knocking on their door asking for information. The same thing with certain parts of the South, certain parts of the Mountain West. Ted Kaczynski is probably not going to show up in the census. That's what allowed him to impute in the first place. And going back to that earlier super chat question when they said they thought it was as high as 20%. Yes, it can be that high. I'm not a big fan of that, but they do it when they're looking at the practicalities of a situation. Like, okay, we're probably not going to get Ted Kaczynski to participate in the census, and maybe it's not a great idea to have people knock on the door to get him. But my view is that that's historically what we're supposed to be doing, so we should be much closer to it than not.
Okay, very interesting. And now I can't bring up the chat, but the books, good books for people to read if you have 5 books to recommend.
5 books to recommend. So let's see. If you understand American politics, read Kevin Phillips' Emerging Republican Majority. If you want to understand the template of how power really operates here and really throughout the world, then read the American Tabloid Trilogy by James Elroy, which includes American Tabloid, The Cold 6000, and Blood's a Rover. I used to say if I was going to teach history in America, I would just teach those books and then apply it to actual historical lessons. You can create a template from that to know what you should look for in certain high-profile incidents to figure out what may really be happening in the world. And then the last book I recommend for everybody to understand the neurological nature of narrative that really revolutionized my understanding of politics, of law, of talking to jurors, judges, everybody, is 3 Uses of the Knife by David Mamet, which is just a small book based on a blues song where he talks about 3 different uses of the knife within a blues song. And his point is that there's a neurological need for narrative within the human species. And until you understand that, you will not know how to tell a story. And if you don't know how to tell a story, you're not going to win over juries, judges, lawyers, the public, anybody in any context, your significant other, you name it. So it's understanding the neurological need for that narrative and how that narrational structure must be architected. I don't know if that's a word either. People are going to check me. It should be.
If it's not, we'll find out in the comment section once this.
Exactly.
And I'm sorry, Tracy Copeland asked twice, what kind of soda is Barnes drinking today?
So yeah, it's the same. It's Zevia, which is made from stevia, which is a Brazilian sugar substitute that's all natural. So it took over 10 years for it to come to the United States because the sugar industry fought using the FDA to prohibit its use here in the United States. But what's great about it is for people who don't want to have too much sugar, but want a sweetener that's not something made by chemicals in New Jersey. If there's a lot of the ones in the diet drinks, I just don't trust at all. And there's been a medical literature that raises questions about their safety. The Brazilian all-natural substitute is stevia, which you can use. Now they have it available in powder form. They have it available in a lot of drinks. Zevia is a drink that's made from it, and I like it for that reason.
You know what? I'm going to reach out to Zevia for a potential sponsor, and I'm going to send them this bit, and I'm going to publish this all over social. Okay, this is off topic. I mean, this is not what we had planned to discuss at any point, but maybe I don't know anything about it. Can't answer. Can Barnes comment on the Wisconsin governor recall and any more info on the case of sexual abuse against kids in the state custody under Evers he previously mentioned?
Yeah, so what it is I help out a couple of lawyers who brought a case. There's been some extraordinary sexual abuse cases unearthed in Wisconsin where people in state custody were routinely and repeatedly abused, usually young boys. And I was trying to help them get recovery. The governor has refused, even though they in fact used the fact that they criminally prosecuted some of the individuals involved so that the state could claim that they are now immune from suit. And so that they have not paid a penny to the families of these kids that they harmed that were in state custody and only experienced that harm because they were in state custody. And so that's why I say Governor Evers is a joke and a disgrace. When he was grandstanding on behalf of in the Blake case, I made that point publicly. It's like, this guy doesn't care about civil rights or justice, or he would make sure the state compensated the people hurt while in state custody by the abuse of state officers, which he continues to refuse to do. But those cases are still going on. We're going to try to take it up to the Wisconsin Supreme Court. It's currently pending before the Wisconsin Court of Appeals, trying to force the state to have to pay recompense for the bad actions of their state employees when acting in the over the custody and control over people in state custody. I assume the recall effort is, there have been multiple successful recall efforts that lead to recall elections in Wisconsin. Over the past decade, I anticipate they will successfully force Evers to be back on the ballot for a recall election, and I think he'll get thrown out.
Okay, phenomenal. I mean, it's interesting. I'm largely unaware of that, but okay, I can't bring up the super chat. It's CCat Dexter. Always wondered why Theranos was such a big deal. Tech has been around for years, i.e. Abbott's iStat system. And that chat just disappeared. Wow, good timing. Okay, and Jenny Rose, has Barnes been following Assange's trial? Perfect segue. Let's.
By the way, for people out there, there's a great documentary on Theranos, so that really goes into it, and it'll show you all the powerful people that were connected to it, that made money off of it, that are not being criminally prosecuted. Because that, to me, is the biggest story of Theranos, is their ability to only have her, the founder, be a sacrificial lamb when she by herself never would have been able to obtain the amount of money she did, but for the Clintons, but for Joe Biden. How has the media managed to not cover this with Biden being a Democratic nominee, that he vouched for her over and over and over again? He's a key reason a lot of money came in the door. How does David Bowie end up in the middle of this? Bowie's he always if there's some institutional scandal, David Bowie's magically ends up in the middle of it. So there's a lot of unanswered questions about how this prosecution has gone, given the information in that documentary. I can't remember the title of it. When I find it, I'll link it. Well, how you put it? Link it in the comments below.
So Dapper Dave says the documentary, unfortunately, is on Netflix.
Yes, I believe that's true.
I say the ultimate irony is on my video today about the Netflix Cuties. The ad that came up before the video was for Netflix. I mean, I guess it's probably not the best video to be advertising on. Okay, it's a good segue to Assange, or at least thank you for the super chat, and let's talk about Assange. For anybody, you'll add the details if I forget any. I'm going to try to do it quickly enough. I take for granted everybody is familiar with Assange, but then I'm surprised at how many people aren't. So Julian Assange, back in 2010, publishes classified information about American involvement in Iraq. I don't think we need to go into more detail than that. It was who provided that to him at the time? I forget the name now.
I believe they have. I mean, not all of it has been confirmed, but the government has attributed almost all of those leaks to then Bradley, now Chelsea Manning.
That's right. So Chelsea Manning, Bradley Manning, we're going to get to that. Provides classified information to Assange, publishes it on WikiLeaks. The accuracy of the information is I don't think WikiLeaks has ever published something that was inaccurate, doctored, or false. Okay, that's what happens. 6 months later, Assange is indicted or brought up on alleged rape charges out of Sweden, which provided, and I think an international warrant for his arrest is issued. In order to avoid being extradited to Sweden, he holes up in the Ecuadorian embassy in London.
Slight substitute there. Originally, he gets bail. Out of the UK. They post his bail, and he's out on bail, I believe, for actually up to 2 years while he fights the Swedish charges. at which point he's supposed to come in for a court proceeding, and he has doubts about what their motivation is, and he goes and gets asylum at the Ecuadorian embassy because he correctly anticipated that they were going to try to seize him at that potential proceeding. So initially he's out on bail, and that's why he's ultimately prosecuted for jumping bail, for which he's already served his time now in the UK.
And that's an interesting thing, good point, because one of the issues is that apparently everybody who raised his bail funds, once he skipped bail, everyone loses that investment, that contribution or donation, which would have otherwise been returned had he showed up for bail. Correct?
That is absolutely correct.
Was it $1 million? How do you remember how much his bail was?
I think it was more than that, but if I recall correctly. But everybody who lost the money and property connected to it had no complaints because they're deep Assange supporters.
Okay, so, important detail. So he skips bail, ends up holed up in the Ecuadorian embassy for 7 years until they come in and they haul him out, drag him from the underarms.
The Ecuadorian embassy did a secret deal with the United States to allow him to be removed from their embassy. So they allow. I mean, if for people who don't know, an embassy is considered the territory of the foreign country. So it's almost like an act of war to go into that embassy, unless you have explicit permission from that embassy. Which it's the whole point of asylum is that you would never give permission for anyone to come in and take someone from that embassy. But the Ecuador ended up cutting a secret deal with apparently Vice President Pence and some others to accomplish that. Also, the Ecuador had a change in presidencies. And even though the left won, or considered the pro-Assange, pro-asylum side won, they have a bunch of financial issues. They're also in a constant dispute currently with Chevron involving the lawyer case that's also being prosecuted here in the States about all of the pollution U.S. oil companies caused in Ecuador, which those companies have not paid Ecuador yet or the people in Ecuador, as far as I know. And so you have a lot of political backstory going on between the Ecuador and the United States. But the most significant one was first country that I know of that allowed their embassy to be breached for someone that they had given asylum to, so that the UK authorities could remove him from the embassy. And he's been imprisoned ever since, pending an extradition proceeding to the United States.
All right, and actually, just to bring up Archetype Next comment. So from what I understand, the Swedish rape charges were not retracted. They were eventually dropped by Sweden, and I think the explanation they gave was the lapse of time made it impossible to prosecute, not that he was innocent or whatever. There was some political spin as to why the charges were dropped, but they were ultimately dropped, or the investigation closed, I should say.
His concerns were ultimately mostly warranted. There is increasing evidence that Sweden brought. For people who don't know, by the way, people think that was like a stranger assault, or I would call it an actual rape case. The allegation was he didn't use birth control correctly.
Yeah, I think one of them was that the condom broke during the act, or that he removed it, and it's called stealthing, I think is the word that I actually learned the first time, is where the individual removes the condom or causes it to break. And that is sexual assault. It's actually sexual assault in Canada, from what I understand as well. So that was
rarely prosecuted, because in my view, that's deeply problematic. That should not be prosecuted as sexual assault or rape. Otherwise, my mother is guilty of it, because my little baby sister was my father was under different impressions when my little baby sister was conceived. And my mother would laugh about it and tell that story for years afterwards. According to this absurd definition, she raped my father. That's why I find that a ridiculous interpretation of the laws. Not only that, it's particularly would be harmful. More women would be prosecuted than men. I'll tell you that. I mean, there's a lot of NBA, NFL players, baby mamas out there that said, "Don't worry," when it turned out there was cause for concern for potential future junior to be born.
Setting aside that, I mean, there's a more legally conflicting issue. Whereas if that qualify, if that's considered rape in certain jurisdictions, and it is, then you have California, where it's a misdemeanor to knowingly expose someone to HIV. It's you're dealing with mutually incompatible concepts of law. So bottom line, he's in the Ecuadorian embassy for longer than 7 years.
Yes.
Gets pulled out. He gets sentenced to 50 weeks for having skipped bail.
That's my understanding.
And now they are having the extradition hearings to determine whether. Oh, I think we forgot one important thing, is that he was indicted in the United States what was a sealed indictment that had been sealed for, I think it was a year or 2 years, was indicted on conspiracy to commit computer intrusion to obtain classified information. So he's indicted in the meantime on separate charges in the United States. He is pulled from the Ecuadorian embassy. Do I want to touch on something? One person once mentioned that there was something about an IMF loan that preceded him being removed from the embassy by a couple of days.
Yeah, that's where there was a deal cut with the Ecuadorian government governing a wide range of disputes between Ecuador and the United States, in which Ecuador used Julian Assange as a bargaining chip to get a lot of things that they wanted monetarily.
Okay.
And Richard Grinnell was connected to this ultimately. It's which is unfortunately someone that a lot of Trumpists have support for. But it turned out that the Obama administration, they were using the Swedish proceedings to afford the opportunity to seize Julian Assange, but they ultimately determined not to bring criminal indictments against Assange because of the deep First Amendment problems of charging someone for publishing. And then people within the Trump administration went ahead with it. There's a variety of people connected to Trump that have lied to him and lied to other people in the Trump administration that misled them into believing that Assange put a whole bunch of people's lives at risk, which is completely false. There's no evidence for that whatsoever. And frankly, Trump betrayed Assange. Assange, was clearly a strong supporter of Trump effectively by being a harsh critic of Hillary Clinton. And I think people set Trump up because now all the supporters of Assange have every reason to get back at Trump between now and Election Day, which is not a good position for Trump to be in. But putting that politics of it aside, the law is that the extradition proceeding is pending, and there's a lot of law that governs extradition, that Assange has good defenses, but I do not have confidence that the judge presiding over his extradition proceeding has any intention of abiding by the restraints on extradition, and most likely will extradite Assange for what will be a show trial in the United States in the Northern District of Virginia, where their trial proceedings are a complete mockery and a joke of American justice.
So, let's do first things first. I read an op-ed today. Basically, it was a British author saying there's no way he should be extradited. It's a political prosecution at best. He's a journalist in any event and is afforded, the protection of publishing classified information that he himself did not partake in criminally obtaining. That's setting things aside. Typically extradition, there is an extradition treaty between the UK and the United States.
Yes. So for people that know, extradition there's an international law of extradition for where there's no treaty in place. And it depends on international law mostly goes by comity. Certain principles that have been adopted like common law over a long period of time become effectively the law. But there isn't a specific treaty between the United States and the United Kingdom for what people can be extradited upon request. So the United States issues a warrant for someone's extradition to that country. That country accepts the warrant or rejects it, as the case may be. And then at that point, what they do is they go in, they have their own internal domestic rules, which govern how the process works and whether there's other restraints on extradition. So I've been involved in multiple extradition cases. Some reached the legal stage, some did not. If you do your job really well, they never reach that extradition stage. The government just decides maybe this isn't the case. This isn't the hill to die upon. But the publicly represented Larry Williams while he was dealing with extradition. He's the father of Michelle Williams, the actress who was the boyfriend of Heath Ledger, had a child with him. Great actress. He's a brilliant guy. He was in Australia at the time, and we end up fighting out that extradition proceeding over an extended time period. And the same basic legal principles apply in the UK as apply in Australia. Some of your best extradition lawyers in the world are based in places like London or Australia, but particularly London. And so in the interesting little side point about Australia, by the way, they often hire private lawyers to be the prosecutor rather than have a state official. So you can work both sides, which I think is fantastic. I think our system of justice would work much better if we did not have permanent government employees be prosecutors, but instead people were hired to be private prosecutors effectively. I think the rate of justice would go up substantially. The life experience would definitely improve. The moral compass of the people involved can't but improve, in my view. So in an extradition, you can fight it on whatever grounds your jurisdiction allows. And in the United Kingdom, if it's a politically, now normally what the extradition requires is that it be a felony in both, that the laws don't have to be identical, but they have to describe a crime that is treated as a felony in both places. If not, then no. And by the way, the same extradition principles in large part, not entirely, but in large part, a lot of the same policies would apply to the Rittenhouse extradition between Illinois and Wisconsin, which is that generally speaking, in most extradition treaties, they don't extradite for misdemeanors. They some countries will not extradite their own citizens, no matter what the situation is. Now, sometimes the way people get around having an extradition treaty, like for example, I dealt with a case where Panama did not extradite to the United States for the crime alleged. They went down. I represented my client after all this happened, but they went down and deported him from the border to a U.S. Marshal at the airport. That's how they got around all the extradition restrictions. But so the U.S. Supreme Court allowed that in a Pinkerton case where the Pinkertons went down and kidnapped somebody, and they said you can't have jurisdiction through kidnapping. There's other courts that say you can't. So one limitation can be is what's being described a crime in both countries, and is it a felony? Because most countries require the crime to rise to the level of felony, which means is generally defined as 1 year or more. So sometimes, regardless of how you label crimes, can what is being alleged be punishable by more than a year in prison in both nations? Then that's sort of you have to establish enough factual basis for that. Other defenses can be it violates your constitutional rights. It's a politically motivated prosecution. It violates some other constitutional provisions. In some cases, if you're a citizen, et cetera, and there can be other provisions that are specifically applicable to you. So for example, in Assange's case, an argument that could be raised is that what they're defining is not a crime under the UK law, because if it were, it would be a violation of UK provisions for freedom of press. There's a great movie out called Official Secrets that gets into someone who was prosecuted like Assange, not for publishing, but in that case for leaking. And ultimately, she was going to bring a duress defense on grounds that the government was up to illegal behavior, so it was necessary to disclose that. So sometimes if a defense is available in one country but not in another country, that can be an argument against extradition.
The most obvious argument that most everybody knows about is that if the person is going to be extradited to a country where they're going to suffer cruel and unusual punishment, then the country will not extradite, knowing that.
And you can expand the definition of that. Like I had been wanting to raise all the times where the U.S. has refused to extradite people where it's politically convenient as showing that there's no need to reciprocate any degree of respect to the U.S. jurisdiction. If the U.S. is not going to respect other countries' extradition laws, other countries have no need to respect U.S. extradition laws, particularly for politically motivated, incentivized cases. But other examples of cruel, unusual punishment, for some countries, that just means the availability of the death penalty. Another argument can be you look at the conditions of American prisons. The conditions of American prisons are a disgrace. You're at substantial risk of physical and mental harm if you're in our prisons. Our prison system is designed to create more prisoners, more criminals, and more hardened criminals, rather than any means of just protecting the community, which is what should be their limited objective, in my view. You can argue for a punishment view, but if you're for torturing somebody, maybe you should go see a shrink. So there's a bunch of arguments that can be made on behalf of Assange. The main one is that this is a politically motivated prosecution that had been turned down by the Justice Department, first ever criminal prosecution of a publisher. But a secondary component of that, because he's basically being prosecuted for publishing information, they've just their view is if you incentivized, encouraged, or helped someone, give them the tools by which they got the information, then somehow you can be criminally liable as the person who leaked the information was. In my view, he has a duress defense available to him, just as I believe Manning should have had available to her ultimately. And so but so there's a lot of defenses Assange has. The main one is that it is a politically motivated prosecution, zero doubt about it. Now, it's not really Trump's political motivation. It's the deep state apparatus within Trump's administration that he has continued to let run amok. That he occasionally disciplines, but doesn't do so in a meaningful manner. And his people are busy not doing a lot. We can see that with updates on the Durham case. I mean, look at all the people. I guarantee, I'll predict it right now. Everybody who erased their phones in the Mueller case will face zero consequence for it. Just watch. And so it's a joke that these people are making decisions. Attorney General Barr viciously attacked Ed Snowden, said no pardon should happen for him. He should be put in prison for life, basically. He said the same thing about Julian Assange, but Barr has still failed to clean up the people he promised. Anybody who still believes in Barr should just go to the tattoo shop tomorrow and get the word SAP tattooed on their forehead, so there'd be public disclosure notice to the rest of us. But the Assange case, I think, is the worst case of what the Trump Justice Department has done. So, in my view.
And actually, I have two questions. One is going to be about the underlying theories as to why they want to get him back. But before then, it's also a very big issue in this case that Assange never stepped foot on American soil to commit the alleged crime, is not an American citizen, and I mean, I guess those are the two big ones. On what basis would the United Kingdom or Britain, England, I forgot the word now, start the E word, bring him over? What's it called?
Extradition.
Well, on what basis would they extradite Julian Assange to the U.S. when the crime didn't occur in the U.S. and when he's not a U.S. citizen? I mean,
well, exactly. I mean, it's a continuous, expansive issue. It's because the U.K. has been the U.S.'s bitch for a long time. And that's why Tony Blair went to war in Iraq on lies. And so Julian Assange is the most significant whistleblower in American history, publisher of whistleblower information in world history. There is no one that compares. He's Daniel Ellsberg times 10. Daniel Ellsberg disclosed the Pentagon Papers. If people want to go back and look at how corrupt our criminal justice process works, look at what was happening in the Ellsberg case. The FBI was secretly in discussions with Ellsberg's judge to make him head of the FBI in exchange for making sure he railroaded Ellsberg. Luckily, Ellsberg had enough key critical allies that got outed, and that's why Ellsberg was never criminally punished. Ellsberg himself has said Julian Assange is the most important publisher in the history of our country, the history of the U.S. for sure, and the history of the world, frankly. This is a guy who, people get mad at what Manning exposed. What Manning exposed was our government doing horrendous things. And why do we want those things to be secret? Why do we want our government doing horrendous things to stay secret? That's not a justifiable basis, in my view, for secrecy. So that's Assange's main criticism, is that the worst government evils hide behind secrecy. Remove secrecy, and you're going to be able to prevent a lot of the government's worst evils, any government. And what he disclosed was extraordinary, horrendous conduct by our military in Iraq and Afghanistan. And that's the reason why Manning disclosed it. I mean, people wanted to attribute it to a wide range of reasons for Manning. Manning was just simply shocked and horrified by what then he, now she, saw. And in my view, any decent, conscientious human being would be. And so just because it's a U.S. uniform doesn't mean morally horrendous actions suddenly become okay. They don't. And Julian Assange exposed him. The only allegation is that he gave some clues to Manning about how Manning could get that information to them. That's what every publisher does.
If anybody, I did a video on this. I mean, I've forgotten the details, but I did a video walking through I don't believe it was the superseded indictment at the time, but it went through the indictment, and it was effectively, indicating how he could potentially get access to the documents. But that's effectively the extent of any involvement, even if it's proven true, of Julian Assange. And Chelsea Manning just communicated documents, and Assange published them on WikiLeaks.
And for those out there that say that Manning or these documents caused any American to die, that's false, because that false lie was put out by deep state apparatchiks early on. They didn't even allege it in Manning's trial, and I guarantee you they would have produced the proof if it existed. So that didn't happen. So people say, well, I'm doing this. All governments say we have to lie in order to protect you. We have to lie in order to protect our soldiers. That ain't why they're lying. They're lying because if you knew the truth, you would not allow them to do what they're doing in your name. That's why. And that's what he disclosed. And that's why his criminal prosecution and his extradition is the most morally horrendous prosecution in the history of free press in the United States of America.
And, let's see here. I concur on Assange. Don't cover up. It's the same with corporate whistleblowers. Don't cover up. I know nothing of the judge who's hearing the case or of the sentiment. You mentioned earlier that it looks like the judge is leaning towards extradition. Why, or what do you know?
She has greenlit every extradition that's ever been presented to her.
That's a problem. Okay.
Yeah. And it's like, I think it's 32 out of 32. It's some crazy number.
Jeez.
And so I'd been in contact with people that are connected to Assange's defense. And I'd always publicly stated that I would help him out, represent him in the United States, regardless of money or anything else, because I find his prosecution so critical and so significant. It's like Rittenhouse's case in that regard. But what Rittenhouse is to the Second Amendment, Assange is to the First Amendment times 10. They're not prosecuting the institutional press for selective leaks that hurt Trump. They're prosecuting someone who did the most damage to the deep state of any person, any human being in world history. This guy did.
And now, to address one of the underlying theories, what do you say to people who say Trump is trying to get him back so that he can be safe in the United States, so he can get secrets out of him?
This is the part of the Q trust the plan stuff in part. A lot of the Q folks were telling me for years that Julian Assange was totally safe, that he was already gone from Ecuador, that he was hanging out some other place. All that was false. He's been in one of the most brutal prisons now for years. I think my problem with a lot of the Q trust the plan ideas is that it tends to encourage very smart people who otherwise independently investigate facts and do crowdsourcing of investigative journalism to not do it because they think everything's fine and kosher, that Trump's really secretly in control, that Tom Hanks and Oprah Winfrey and Barack Obama are down in Guantanamo on child abuse charges. No, and no. That the system's really in control. Well, where are those Durham indictments? Right, we're now into September, and what happened this week? Durham's number 2 person resigned because she was mad about even having to write a report before Election Day. Do you think she's resigning in protest of writing a report if they're about to bring a bunch of big indictments? Do you think Peter Strzok's out on a book tour because he has any reason to fear anything? No, the reality is the Assange prosecution is a deep state prosecution. Trump and people close to Trump were hoodwinked into supporting it. And it's an embarrassment. It is contrary to Trump's core values for him to do so. He publicly praised Assange throughout 2016. I hope that he will return to that and pardon him, because the message of the Assange indictment is a deep state power grab that says that if you publish our dirty, dark secrets, we will put you in a hole for life. And that's why it is Assange is symbolic of everyone's freedoms, for freedom of press and for us to know what our government is up to. He published the only publisher to not ever get anything wrong. He, by the way, went to great lengths to make sure things were not illicitly published. When other people got access to the cables and they published them without his approval or authorization, he tried to give notice to the government so they could take corrective remedy before it got out publicly, because he wasn't the one publishing it. He just was tipped off to it. So he's been very noble in his publishing attempts, has tried to mitigate all forms of harm, has his own personal peccadillos that doesn't always leave him with the best friends and allies around. But that's the nature of an idiosyncratic independent soul. He's the Thomas Paine of the modern world. And for anyone to sit by and watch him get criminally prosecuted in the name of the deep state is not a true friend of democracy or freedom.
It's going to be, from a timeline perspective, what do we think we have to wait before we get a judgment?
They're going to have multiple presentations of testimony and hearing. I think it will be mostly a show trial by that judge, but her decision is appealable. And there is a fair chance that someone up the food chain in the UK recognizes how problematic this is and does something about it. But I would say 1 in 10. And I think his only likely remedy, the U.S. court system, the way they prosecute national security cases in the United States are a joke. They're an embarrassment to our constitutional liberties. You're not meaningfully afforded the opportunity to cross-examine your witnesses. Things are done in secret in massive degree. Think about the Roger Stone trial, but make it on steroids.
Yeah, well, people don't, I know that I'm more sensitive now to the nature of the UK court system because it's much like ours, and ours is already one step above yours in that respect. So people should appreciate that.
Just look up what's happened to whistleblowers, and if you have any idea or any doubts about the intentions of Assange, look at what people like William Binney have said about him. Look at what people like Daniel Ellsberg have said about him. The greatest whistleblowers in American history have all celebrated Assange as key to the ability of whistleblowers to have a voice in the future. And that means the people's right to know what our government is up to and when they're up to bad stuff. This is a deep state case. This is the deep state case of all cases.
Amazing. Okay, well, we'll see where it goes. It is fascinating, and if anybody's not familiar with how UK courts can go dark overnight for an extended period of time, Tommy Robinson was another situation where mind blowing. Where at the time I said, love him or hate him, this is a North Korean style court system, not the beacon of democracy of the Western world. Mind blowing. But we'll see. Well, there hasn't been news on that in a long time, but yeah, if anybody doesn't know. Okay, a lot of people have been asking, we're going to shift the subject because a lot of people have been suggesting or posting comments on George Floyd that apparently new evidence was released. I'm not familiar with it, but from the comments, are you familiar with the new evidence that apparently he swallowed drugs? And I'm not sure if it's in this case or another case.
It's a couple different things on that. One little transition before I forget. It turns out somebody in the White House is following either us or my discussion of the Covington case in the Sixth Circuit, because somebody in the White House finally figured out that Trump can assert the Westfall Act. And so this week in New York, the Attorney General Barr, and he was, by the way, in his quotes at the press conference were almost quotes from my brief, which would actually limit the scope of, which means maybe the Justice Department will join in my brief. We'll find out. I'm going to ask him to, because he said, look, anytime someone is answering questions of the press because of their job, that is considered immune under the law within the scope of the Westfall Act. And he said, so that's why they're stepping in and taking over all the defamation cases against Trump. So all these defamation cases they had these high hopes for are going to go nowhere for the ones that allege something that Trump did while he was in office. There's others that allege something while he was on the campaign trail. But for the rest, the Department of Justice is now substituted in under the Westfall Act, and Elizabeth Warren apparently clued them in to the utility of it for Trump. But by Attorney General Barr's statements at the press conference, he was quoting my interpretation of the Westfall Act rather than the Sixth Circuit's. So I'm hopeful that might be a cue. So even though I'm otherwise quite critical of Attorney General Barr, I'll otherwise be very kind to him in case they join this.
Maybe he'll take some of your advice as constructive criticism and not
always
personally.
always.
Very cool.
But yes, in Floyd's case, there's more evidence of drug use. Now, by the way, this shows you where the case is going too, though, good, bad, and otherwise. So there was additional autopsy evidence that there's no evidence that there was any physical harm to his throat from the knee on the back. The second part was the conclusion that just the amount of fentanyl in the system would have killed him, period. So Chauvin's defense lawyer made a motion to dismiss on grounds that precluded him from being charged for murder. Judge will find that the autopsy still provides a basis by which a jury could conclude that it was a combination of the two, not just fentanyl by itself, that killed him. But that will be a question for the jury ultimately. The other component was that he was taking drugs right when they showed up. There was evidence of this early on. Actually, Alex Jones, one of the people reporting on it, he broke down the tape and showed that it looked like Floyd dropped another bag of drugs right as he was getting picked up, so that he was probably doing drugs. He had just ingested drugs right before they arrived or right as they arrived. There's additional evidence of that. The defense team for the police officers wanted to introduce evidence of Floyd's long drug history abuse. And the judge completely denied it. And so what I told people, in fact, somebody was asking me this the other day, what I thought was going to happen in the case. I said, historically, in police abuse cases, where there's controversial evidence on potentially even on both sides, but even cases that were really strong abuse cases where the officers walked, it's because they got transfer of venue. So the 41 shots case out of New York, where the cops, fired 41 times and killed a guy that was unarmed. They got that case moved from Brooklyn to Albany, and they all walked. Rodney King famously moved from South Central to out in the Valley, and that's where they all walked. And so I don't think this judge is going to move venue. I think that if the case is tried in Minneapolis, the cops will still be convicted despite this evidence. They might overturn it on appeal a couple of years later. Chauvin has problems anyway. He was doing tax evasion, wasn't filing returns, was pocketing excess cash. So he's got a host of problems, so totally separate from this case. He's going to prison no matter what. But the other officers, their defense has got stronger. I never particularly liked the charges against them because I thought it was, were they supposed to tackle the other officer? Is this a few good men situation where they're supposed to stand up and do something and their failure to do so now is criminal homicide? I thought that was a bit of a reach. I thought Chauvin deserved to be prosecuted because it was excessive force, even if it didn't cause death.
Well,
you could have it,
that was I'm pulling up these comments because that was the thought experiments I always go through is, what additional piece of information would I need to have to change the opinion that I've already come to? So two things. From the initial autopsy, there was no indication that he had swallowed bags of drugs. Look, and if the news is that, or if the developments are that he had ingested bags of drugs that were slowly expanding or releasing in his stomach while he's, having a knee put on his neck, I'm not sure that it would be closed-minded to say that wouldn't change anything. That's sort of like the mules who have the cocaine break in their stomach and then die. If there was some random contemporaneous thing happening at the same time, you would have to factor in the drugs in their stomach. This is news to me. I don't know why it would not have been disclosed with the previous autopsy, though.
Well, one other interesting component there is it appears that Floyd was a rat informant because they're asking for all of his informant files. So that may be that raises all kinds of interesting questions. Was he Chauvin's informant? Had he informed against Chauvin, given that Chauvin was involved in criminal behavior? I'm just curious where that potentially leads. That may not lead in a way that helps Chauvin.
I know there's a thing I recall you from the beginning. You had mentioned that it looked like there was a prior relationship between Chauvin and Floyd.
Correct, and so just his behavior was particularly. It didn't strike me as abusive cop behavior by itself. It struck me as something else. And if there's there's now evidence that there was definitely a backstory of them getting into fights when they were working private security. But if it turns out Floyd was an informant and may have informed at some level against Chauvin or somebody connected that Chauvin was trying to protect, or if they were overlapped in the same circles. So I think Chauvin, if the case is tried in Minneapolis, they're going to be so exhausted by everything that's happened, they're going to convict Chauvin no matter what. I think the other officers may walk. There definitely is evidence. A jury could fairly conclude that Floyd would have died anyway, that he did not die because of the police behavior that day. There's evidence they could also conclude that he did die of that, because it's always when you have a stress-induced death, and the autopsy could not rule out stress as the cause of death or a contributing factor. And clearly being on his back in the way that he was and on his neck in the way that he was for the length of time that he was would cause stress. The fact that he may have died anyway is a defense to the homicide charges, but it's not a defense to the excessive force charge. And I think a jury could conclude otherwise based on the course of conduct. So I hear people saying, "Oh, now he's going." I don't think that he's going to walk. There's too much bad history here. Chauvin tried to plea very quickly. I think more bad stuff will come out about Chauvin over time. The judge is signaling that he's going to help secure convictions in the case. I don't like judges to do that, but that's what I think he's heading to do. So I think they will convict Chauvin, but I think the other officers, a little bit rough to accuse them of homicide under the circumstances. So I think you may see a split verdict.
Well, so and I'm pulling this up here. Denny RN says swallowed extended release fentanyl, which was clearly in his tongue. Watch the video, for God's sake. Well, I don't know how clearly it was on his tongue, because if this is only coming up now, despite
purportedly it's on a body, some body camera gets it. Okay. But I have not seen the blown up evidence. I've just heard that. But I knew that Jones broke it down in detail, and what he was showing suggested that he got nervous about having drugs when they arrived. And one thing some people do is ingest it. And that's a bad idea, but that's one thing rather than just drop it or try to hide it. So that may have been what occurred. It's not crystal clear yet, but that's my understanding of what the body camera evidence will show. Now, if the cops say they knew that creates a different set of problems for the cops. So a lot of these defenses are a little bit tricky, because if the cops say, "Hey, I knew he had all these drug problems," well, then why did you behave? That puts you on a certain duty, like the Rochester cops, that changes how you're supposed to handle the situation. So under their training. Now, by the way, the biggest defense Chauvin has is their training actually required him to use that tactic. Not for that length of time, but that's his best defense, is that the city of Minneapolis had failed to exclude that from their training, which they should have a long time ago. I get the cops who follow me online are going to yell at me again, but there's good reason for it, folks. It causes more risk than reward.
And that was actually what someone had mentioned, that the move was not illegal and was part of, I want to say protocol, for lack of a better word.
But I still have doubts that that's why Chauvin was doing what he did. That if you look at his behavior, his body language, other things, 8.5 minutes, I don't think he was treating this just like I'm just following my guidelines. I have my hunches, and then I said that right out of the gate, and it turned out the guy had 18 prior complaints against him, has been doing undercover illegal sources of income for 3+ years. To such a degree, he was making so much money undercover that he refused to file tax returns. By the way, that's a sign of a sophisticated criminal, because given that he has a W-2, he was going to get caught easily not filing returns. So why did he not just file anyway? Because he didn't want to lie on those returns, because that's a felony, whereas failure to file is just a misdemeanor. So this is a guy that knew what he was doing at a sophisticated level. So I think he was engaged in a wide range of criminal activities outside his police job.
Very interesting. It's certainly going to come out during the trial. I would imagine.
Maybe, unless it depends on who it was he was corrupt with.
Ryu Kiruto says, I know Barnes said that the cops who allowed the guy to die from the spit masks are in the wrong, but could it just be he died from excited delirium? So
the autopsy did conclude that there was damage to his throat, and that asphyxiation was the cause. So that in the asphyxiation was, so there the autopsy does not support the police. So the autopsy counteracted the excited delirium theory when it said that asphyxiation was a key contributing factor to his death, and the asphyxiation was from them sticking his head into the ground in a ill-equipped quote unquote spit mask, because it's not a proper spit mask what they put on him.
And if this is my own edification, if you know the answer. So the standard people, you have the eggshell defense or the eggshell skull defense, where you have to take the state of your victim as the state when the act occurs. Does that apply to police officers as well?
Yes, it applies across the board. So just because you happen to have a very vulnerable, arguably even more so if they have no knowledge of it. So if they have knowledge of it, that makes their acts more intentional, right? Like it might be reckless if they don't know about it, reckless homicide as opposed to intentional homicide. But if they know somebody has a certain susceptibility or vulnerability, or is in a particular at-risk state, and they accelerate the worst consequences of that at-risk state by their own behavior towards him, arguably that's intentional homicide.
I mean, and I'm thinking, just to take the example we had earlier, if the cops know someone is a mule and has bags of cocaine in their stomach and then punches them in the stomach and breaks one of them, that would be, I guess, right, that type of example.
Yep.
Okay, well, that's very interesting. I mean, I'm going to be following that. I wasn't aware of that development.
I'm pushing the Floyd case to 2021, so it won't happen before the election.
Okay.
If there's a bunch of like deals done that don't sound right, that will mean Chauvin was corrupt with the set of people that the Attorney General needs to protect. If they go to a full-scale public trial, then the Chauvin's corruption, it doesn't implicate anyone the Attorney General wants to protect. So that'll be the other thing I'd be watching for.
Someone's asking, Dapper Dave, and there was another person who brought up the comment about his tax returns. If they don't get you on the crime, they'll get you on tax. But
he's already been charged.
Why would there be an investigation on his tax? There was no reasonable suspicion that he was being charged for another crime?
Oh, clearly they put him under a massive inquiry. But here's my view. That happened very fast. So I can tell you historically that doesn't move that fast. So that tells me somebody in the government already knew it, which tells me he was corrupt with a different set of actors. So and his attempt to plea early struck me that way. In other words, I believe that there's reason to believe, put it this way, that Chauvin's corruption touches politically connected people in the Minneapolis area.
Okay, interesting. The prediction is in, Robert. We'll come back to this at some point in the future.
If he gets Epstein, then we can count that one in that column.
Eric Blank says, thoughts on the bump stock ban's recent developments?
So yeah, those cases are going through, and whether or not they're going to be Second Amendment violations, and I don't have any thoughts beyond my original thoughts. I mean, I think there's problems with those bans from a Second Amendment perspective, though not as bad as what California tried to. That's probably heading up to the U.S. Supreme Court.
Okay, now I want to, before I forget, because we're going to probably have to wind this down in a few minutes anyhow. I don't know if I'm supposed to mention their names, but I got emails. One person who said, Robert, David, please stop referring to it as a two-tier justice system. There's only one tier of justice for the lowly people, and above them it is lawlessness, was the comment. So that, and he sent me another comment, but I couldn't read the article. It had to do with Britain, but I don't think it's proper for this stream. Another person said by email, love your level-headed approach. Your breakdown of events are awesome. You should cover California's new law, SB 145. People are up. Okay, well, we discussed that as well. And if you know who that is, person, if you're watching, I won't mention your name just in case you don't want me to, but thank you. And let me see. There was one more. I was a court officer, worked with the DA. I just had a question regarding you, not as a lawyer, someone who knows a little better than me. Do I as a citizen have any small claims recourse against YouTube for banning, censoring, etc., those that I watch on YouTube, unfair business, any other violations, etc.? Really curious. Thank goodness I remember this one. Robert, I don't benefit for the manner in which I use YouTube. I don't benefit from consumer protection laws of California, correct?
You should, but the courts are not enforcing it. So there's basically saying Section 230 prevents almost every kind of lawsuit. So because I brought unfair competition, consumer protection claims, equitable claims, you name it, other than like your Patreon type claims, with those claims that where they went after basically did mass arbitrations because they had an arbitration right. That may actually be a bit of a loophole that you can utilize. But right now, the courts are basically saying any form of censorship is immune from any state or federal cause of action under Section 230. So there's almost nothing. Like, for example, not to go back to the Wood, but people were asking me, Wood and John Pierce were talking about, they're going to bankrupt Twitter. Those are frivolous claims. That won't happen. Those cases will get thrown out of court early. So people have given their money for nothing. That's the reality of it. I don't like that reality, but it is the reality of it currently. So it's almost impossible. That's why the focus has to be legislative change, has to be political change. That there has to be maximum pressure brought on the legislature to bring change, because the courts are closed to any meaningful remedy in that respect right now.
Okay, now I'm looking for Kayak Dog's comment, and I don't know if I took a picture of it. Kayak Dog, put the comment back in the bottom. Do not do it by super chat. I'm going to get to it right now. I'm sorry about that. Anne Marie Quinn, put your comment back in there. Okay, but before that, Robert, if hypothetically someone looks at YouTube and says, this is not a question of censorship, it's a question of deceitful business practices.
That was my theory. That's what I sued Twitter for. That Twitter promised to be the free speech zone of the free speech party, the free speech wing of the free speech party. So they made consumer promises. They made equitable promises. They had unjust enrichment because they got rich off the falsity of those promises. And what the court said is, no, look, Section 230 is supposed to be exclusive. And so that if what you're talking about is in any form censorship or suppression of access to those social media sites, you don't have a cause of action unless Section 230 says you do. And they basically say Section 230 doesn't allow anything. So there was supposed to be a good faith clause provision. Doesn't matter. It was intended to, if platforms were acting like platforms and not like publishers, doesn't matter. Courts don't recognize that difference either. So the courts are completely closed to any ability to sue the big monopoly social media giants, which should not be reason for resignation. It should be reason for action towards the legislative branches to change that. And it has to happen at the federal level because Section 230 is interpreted as preempting state and local law.
And Aquapuppy says, even though the join button is also a subscription Patreon style agreement. It's interesting.
Yes, that's my view too. But unless all of the social media giants have changed their arbitration clauses and provisions to not provide for what Patreon did, so they can't be subject to that mass action the way the troll Owen Benjamin, his people did.
That's what people don't really appreciate, is that the Patreon lawsuit succeeded not because of the law, but because of the contract that was drafted that had deficiencies in it, to say the least. My issue, Kayak Dog, I'm doing my best, but my issue with YouTube is the deceitful business practices would be what I've brought up a number of times in previous videos: greenlighting a video so that you are induced to publish it because you think you're going to get AdSense revenue, and then yellow lighting it either right after or at some point after without even notifying you. So your expectation of what that green light meant has now been basically, you've been duped. You've been basically duped, and they have not advised you that the conditions of that contract have changed. I'm sure there's a claim there. I just don't know. Am I going to be one to bring it in California? I don't.
I mean, the short answer is they're going to reject it under, in all likelihood, under Section 230 provisions, because the way they're interpreting it is, if the action you're complaining about has something to do with limiting access or limiting monetary reward for access, they interpret all of that as being subject to Section 230 immunity. And so, because that was I looked at every suit that had ever been brought, tried to find the most creative ways to hit him, went after him, brought it in front of a Republican judge in front of her in a Republican jurisdiction. Even she wouldn't buy it. She wouldn't go along. They just see, oh, you're suing YouTube. Oh, unless your contract is to provide an employment service to YouTube, Section 230 applies. Case thrown out.
Because it's nonsense only to the extent that you're not even suing them as a platform or a public. You're suing them. They're offering a service. You've subscribed to the service, and they're changing the terms of it effectively after you've agreed to it.
They made a promise and they broke the promise. I mean, all of them have consumer fraud claims. All of them have unjust enrichment claims at some level, because they promised. The reason why YouTube has a near monopoly, the reason why Twitter has a near monopoly, the reason why Facebook has a near monopoly is they promised to protect freedom of expression and freedom of exchange, and they promised to monetize those people who produce things that people wanted to watch and see. And then they decided to unilaterally change the rules after the fact once they became monopolies. Exactly what the antitrust law is supposed to prohibit them from doing. But they're not enforcing any of the laws as to them because they've reached that sort of big trust 19th century kind of standard. They are the Standard Oil of America today. And the only way that's going to change is if the legislature breaks them up. The judges sure ain't going to do it, unfortunately. I agree that in theory, all those claims should exist. In reality, courts are closed.
Very interesting. Okay, now we can get Kayak Dog's comment, and don't be hard on Kayak Dog, but Kayak Dog, super chats or not, I do my best, but I miss some of them. Barnes made a comment about Trump's fans trusting Grinnell. Can he elaborate? Why would this trust be misplaced?
I like Grinnell, but Grinnell was the middleman to get Assange prosecuted and to get the deal done in part, along with Pence. And so, and people that like Grinnell went around attacking anyone who was defending Assange. And so they did so in mediocre ways. So they put Trump's political status at risk, because there's a lot of people that are strong Assange supporters who are now going to be searching for dirt on Trump to expose between now and Election Day as payback for Trump's administration prosecuting him. That's just an unfortunate reality politically. But even if you put the politics of it aside, the law of it was bad law, and it was based on a lie. That these people spread a rumor and a false statement. Now, I don't think Grinnell was spreading it. I think he was repeating what he had been falsely told. He had been told, but basically strong advocates like Cassandra Fairbanks for Julian Assange were being criticized for continuing to defend Assange on bogus grounds because Grinnell was complicit in getting Assange prosecuted. Now, I think Grinnell was just carrying out other people's orders, but you can't be you're not taking on the deep state if you are facilitating the deep state's favorite prosecution of their most hated adversary. So that's my problem. I personally will never trust Grinnell again. He knew he should have known better. So and by the way, Grinnell, before he got on the Trump bandwagon, used to be more of on the neocon bandwagon. So sometimes what he's done has been more personally ambitious than principled in motivation. But I think what happened there made me not trust him. I think he did good work when he was at the director of national intelligence position and by declassifying a lot of stuff. And so I like him. He's better than 95% of the people in Washington, but he made a major mistake by getting himself involved in the Assange case and by allowing false stories and false information to circulate to Trump's people that justified that unjustifiable prosecution.
Okay, amazing. And I just got the text of notification from the supreme power. So okay, I'm going to go through these super chats, and then I have to go put some kids to bed. Okay, Lucas DeYoung says, I'm late to the chat, but I was wondering what Robert thinks about rumors of FinCEN suspicious activity report leaks as an October surprise. I don't know what that is. What is that?
So FinCEN is the financial center which tracks all transactions that banks have to do reports to. If they have, they call them SARs, suspicious activity reports, or currency transaction reports, CTRs. So whenever it's part of the anti-money laundering laws, but really it's about supervising major financial transactions. So if for example, you go in and do a cash transaction over $10,000, that triggers a currency transaction report that's sent to FinCEN, operates in Detroit, part of the Department of Treasury. It was FinCEN that was employee that was doing illicit leaks about Michael Cohen and other people. I think they ultimately caught the IRS employee connected to, though FinCEN doesn't have to have IRS employees working there. And so there's risk that there's going to be some suspicious. The other thing they do is suspicious activity reports, where they think someone is trying to avoid a currency transaction report by breaking up a transaction. Like, let's say they want to get 40 grand in cash. They go to 8 different banks and do 5 grand in each bank in the same day. They say, well, really, that was meant to be, that should have been reported. It wasn't. The bank files a suspicious activity report because they think you're engaged in money laundering. And so the theory is that someone at FinCEN will have access to that information and will leak that information in a way that will be helpful or hurtful to one side or the other. That's already happened during the Trump administration, but when the leaks have come out, they've only been hostile or hurtful to someone that's allied with Trump. I don't anticipate FinCEN being the source of anything in October.
Okay, very interesting. That's the one we just brought up. California Department of Justice is delaying COE for so long that it is forcing gun store closings. Judicial relief possible?
Maybe. That was the scam very from the get-go, was my view. That what they were doing is, like, they were saying, well, we can't do background checks right now, so even though you have a legal right to buy a gun, your background check won't clear for 6 months. So you can't actually get one. So they were doing that in a range of Democratic jurisdictions in particular. I think there would be a potential remedy. The problem is you have to go to courts in those jurisdictions, and those are liberal jurisdictions where they're finding excuses not to enforce the constitutional rights of the individual quite frequently.
Okay. And Viva, can you sue Google under Canadian law? There's jurisdiction clauses, I'm sure, in the terms of use that are going to preclude me from even taking them to small claims down the street. But I missed one more super chat. Okay. Anyhow, I think Robert, we've covered pretty much everything.
I do believe, unless I'm, I think that covers most of the updates for the week.
We did.
For people that want to know, though, the wiping the phones should never have happened. Those are official records, so it's not just independent of whether the product. If something is not subject to subpoena, generally you can delete it, destroy it, shred it, however you want. That's why Arthur Anderson walked, and were the 9-0 unanimous decision that they couldn't have obstructed justice because they did not have notice of a subpoena. So even if they anticipated it, they could shred everything they wanted that day. You can watch, I think it's Devil's Advocate, the movie with Al Pacino and maybe Keanu Reeves. It's Keanu Reeves.
Keanu Reeves.
As there's a scene in there where a lot of the lawyers are shredding documents on eve of subpoenas. They do that because until the subpoena arrives, it's legal. I sent a lot of notices to a bunch of congressmen this week in another case that I can't get into the details of, but just reminded about 100 congressmen that they needed to keep some documents because my case was going to reveal some issues that were related to whether they'd been up to something bad. And so I did that so that they wouldn't be going to the shredding machine when they heard about my case. So that's how that sort of works in general. But what's different is with official records, like the Clinton emails case. Those are government records that you can't destroy. Like, it became briefly a debate about when Nancy Pelosi did the whole tearing of the State of the Union. Did she tear an official statement? It probably wasn't necessarily an official statement, but it might have been, and that would have been destruction of official documents, which for archivist purposes, but also for Freedom of Information Act purposes, you can't destroy that stuff. And it looks like the Mueller team learned the lesson of Peter Strzok, which was just delete everything. Like Andrew Weissman, one of the most corrupt prosecutors around. Someday I may have to add him as one of our eternal truths. Sally Yates is still corrupt. Epstein didn't kill himself. Rittenhouse is innocent. And Andrew Weissman is the worst prosecutor in human history. But I'll figure out whether we keep the fourth. But it turns out Weissman accidentally put in the wrong password 10 straight times so that it would delete his entire phone, for example. These are deliberate acts meant to cover up what bad complicit corruption they were involved in. It goes to why the problem with Durham letting Kleinsmith off the hook. Kleinsmith doctored those documents and faked the information so that they could lie into the FISA court to get a bogus FISA application to retroactively justify all their illicit spying after Mueller's team took over, not before Mueller's team took over, when Kleinsmith was then working under Mueller's team. Now that we have destruction of information under Mueller's team systematically, apparently over 30 phones wiped entirely, more evidence that Kleinsmith was likely complicit in acting at the orders of someone like Andrew Weissman, because Mueller had a mental state around like Joe Biden's. So Weissman was functionally probably running that entire operation. But by letting Kleinsmith off the hook, they prevented the ability from meaningfully prosecuting them for that related issue in all likelihood. So while nothing will likely happen from it, people's beliefs that it was a crime just because there was no subpoena pending didn't matter, because those were official government records and official government documents they could not destroy and delete.
Amazing. I mean, yeah, absolutely. And now Truman WH says, super chat, TED Talk psychopathy. Can anything be done about DAs whose selective prosecution is politically motivated? Robert and I, we've touched on this.
Yeah, there should be. The law should punish people prosecutors who do not do justice or violating their ethical obligation. Selective prosecution is a violation of the First and Fifth Amendment to the United States Constitution, applied to the states through the 14th Amendment. But unfortunately, nobody does anything about it in the judicial branch, and consequently, prosecutors get to walk, nor in the executive branch, unfortunately.
All right. Let's do it. We're out of here. Unity 2020, Brett Weinstein thoughts. I'm not sure what that means.
I represent Unity. Brett Weinstein has created a third-party independent movement that's going to nominate people from both parties. And he's trying to create it as an alternative so that people can have independent choices that could be uniting ultimately politically. I represent Unity 2020 in any legal claims or legal actions they may have to make sure they have access to the ballot as needed. He's in the Ralph Nader tradition of wonderfully naive. So the people that are critical of him say, look, you're too idealistic, Brett. There's no doubt he's too idealistic. But here's the flip side of that. What I always tell people about Ralph Nader, who's also crazily naive about things. It's always the people that are the most naive that change the world. So Brett Weinstein's a very smart man, very conscientious man, and credit to him for trying to take action to try to remedy the situation. Is that the problem is he sees it.
Amazing. Here now, somebody wants to show you. I think you got to get into this. Is Harry,
the guinea pig.
Look, it's kind of actually a majestic animal.
I know. It actually looks like a little dog almost. It looks like a little rabbit. Looks very huggable.
Yeah, like it's got a little beaver face, but he actually has a personality. It's kind of amazing.
Yeah, that's great.
He bites. Okay.
Oh, yeah.
On that note, we're good.
Which way does he? Oh, this way.
Okay. That is the cue to exit. Everybody, thank you very much for tuning in. It was another amazing live stream. We might be doing this either, if not every Wednesday, every other Wednesday maybe, but news will come. Robert, stick around. We'll talk about this after we get off. But everyone, thank you for coming. It was phenomenal. Robert, thank you as always. Unbelievable as always. People,
thanks everybody.
The weekend.
Wait, Ethan wants to say hi.
No, he doesn't. All right. See you guys.